one of the medias present here in this court, that is the Namibian Sun. They just reported 20 minutes ago, and I will read verbatim, that the ACC investigating officer, Obeti Inambao, revealed that after Jennifer Hamukwaya left NAMCOR, she took up employment at Erongo Petroleum CC, where her romantic relationship with Austin Elindi is believed to have begun. Her defense, however, bemoaned these revelations, urging that Hamukwaya not to be subjected to scandal and that her private matters be excluded from bail proceedings as they serve no relevant purpose. The magistrate, that is you, your worship, said that the affairs of the accused persons are not relevant to the current proceedings and instructed the state to recall their witness to order, directing that only information pertaining to the bail application should be disclosed. The report is by a certain Rita Kakelo. I'm not sure whether Kakelo was here or if maybe she's here. Maybe she speaks Swahili or some other languages. But our request, your worship, as the presiding officer, is to warn the media personalities, to tell them to not to distort what is being said in court. With due respect, Jennifer Hamukwaya never worked for Erongo, and when she left to a through a settlement agreement, she never resigned. I don't know where this Rita Kakelo is, how much money she was paid to distort all this, but my clients deserve the right to seek redress in another court. Please, court, your worship.
Yes, it's in order the court has no control over what is reported on the media. Yes, you have indicated correctly you are going to seek redress. You are an officer of court, you exercise your client's rights. Yes, but whatever is reported in the media is out of the court's control. Yes.
Your Worship, I really have to, maybe it's the way my colleague framed it, but you will recall, Your Worship, that when I came into the proceedings, the order for the media to be allowed to stream these proceedings live was already made. So we took no issue with it. However, when the media is allowed to stream proceedings live, if this is the manner in which they are going to stream proceedings by distorting facts while they are allowed to be in the courtroom, then we will also have to start thinking about objecting, because that order was made before we arrived on the scene. So it's not an issue about, Your Worship, about whether it's defamatory or not. That's not the point. It should be around on what conditions that live streaming is allowed.
Yes, Mrs. Gebhardt, maybe before you proceed, I must cut you there. There was no order made by this court for the live streaming. Yes, the media took their application or their intention to live stream this to the Office of the Judiciary. It was granted by the Office of the Judiciary, and no order was made by this court. In fact, even on that date when the matter started, I was provided only with a copy of the permission from the media to live stream with certain conditions. Therefore, it's not correct to say there was an order made by this court. That is an issue outside of this court.
Your Worship, if those are the facts, then we are in the same boat. The order was made somewhere else. Whether or not the interested parties like our clients were consulted is something then we will take up with the Office of the Judiciary. The impression that was given to us, whether rightfully or not, and it appears now to be an incorrect impression, was that the order was granted by a court to live stream. But we will take this up with the Office of the Judiciary who granted the order, because that is then something we need to deal with them on what conditions that is granted. As it pleases you, Your Worship.
Yes, just for the, no such order was made by this court. We started in court, all of you counsel were in court. There was no application to this court for such, and no such was brought before this court. Therefore, it's outside of the court.
Your Worship,
Yes.
I understand that,
Yes.
but we were made to believe that the order was granted before we came on record because the matter had already started, except for the applications for bail. But like I said, Your Worship, it was not meant to impugn the decision onto you. If it was taken by the judiciary, we will deal with the judiciary on what those conditions are.
Yes, then we can proceed.
Thank you, Your Worship. Now, Mr. Inambao, there is just an issue that I want us to deal with as we proceed after our lunch break. This relates to the issue that we have dealt with in the testimony of Mr. Mulunga. I just want to know, I think it's applicant number 4, if I'm not mistaken. That relates to the car. Can you just, the motor vehicle in question, can you just relate that to court?
Your Worship, as we were busy investigating the case, we did receive intelligence and information from various sources which indicated that a vehicle, an Audi Q8 or QRS8, Your Worship, was bought for Mr. Mulunga by Mr. Simaneka. Your Worship,
Proceed.
yes, evidence, Your Worship, established that this vehicle was bought from Audi Center to the value of a little over 3 million. During 2023, Your Worship. Of which there was an upfront payment or a deposit of a little over 900,000 that was made on the vehicle, Your Worship.
Your Worship, it's not an objection, and I don't intend to disrupt the court proceedings. If the witness remembers in which month, he only mentioned the year, that will assist us, Your Worship. Please, the court, Your Worship.
So you can proceed.
Your Worship, I can look up the month, Your Worship. We do have the contract, or Your Worship. I just, for some reason, the date is a little bit off right now, but I can still get the date, Your Worship, to give that date, Your Worship. And the precise amount of the deposit that was made towards the vehicle deposit.
All right, just hang on. There was a suggestion made, or evidence, in fact, to the effect that the fourth applicant, Mr. Mulunga, just took the car for service on behalf of Mr. Victor Simaneka Malima. Do you have any comment on that? In other words, it's not his car, he just took it for service. Do you have a comment?
Your Worship, the sources had provided us with photographs of the vehicle, and the information was that Mr. Mulunga had been using this vehicle, Your Worship. I and one of the other investigators, we personally saw Mr. Mulunga as well using this vehicle sometimes during last year, Your Worship. Your Worship, to try and quantify, rather not quantify, Your Worship, But to try and find evidence, Your Worship, we looked at the NATIS registration documents of the vehicle in question, Your Worship.
Yes, you looked at the NATIS registration documents.
Where we found it to have been registered under the name of Miss Heleni Kamati.
Yes, did you find out from Miss Heleni Kamati if she knew about this motor vehicle in her name?
That's correct, Your Worship. Further investigations established that Heleni Kamati is a cousin of Mr. Mulunga. In fact, a namesake of Mr. Mulunga's mother. We reached out, Your Worship, in terms of the investigations where we interviewed her. And she confirmed that she does not own a vehicle, Your Worship. During February 2025, Your Worship, we once again visited Audi Center to try and find out as to who used to bring this vehicle for service, Your Worship. Where we found the records that Mr. Mulunga had brought the vehicle for service, Your Worship.
Proceed.
Your Worship, the vehicle is part and parcel of the Commission's investigations. To date, we are still looking for this vehicle, Your Worship.
Proceed.
And the reason why the Commission, Your Worship, was interested in the specific vehicle is because there was a relationship between Mr. Simaneka Victor Malima with NAMCOR, the former employer of Mr. Mulunga.
Proceed.
A relationship which started sometimes during July 2018 when EcoFuel Investment CC entered into a fuel supply agreement with NAMCOR Trading.
Who owned EcoFuel as of July 2018?
EcoFuel, Your Worship, right now I can't really confirm as to whether, because currently EcoFuel is owned 100% interest, or rather held by Mr. Simaneka. But during 2022, for the transactions that we were investigating, its interests were held 50% each by Johanna Munjeko and Martha Antindi. So I can just confirm the dates as to when is it that they... but in terms of the beneficial ownership information of the entity, it's 100% for Mr. Simaneka, Victor Malima. It was through this agreement, the fuel supply agreement entered into by EcoFuel Investments, which resulted in the debt of 73 million. Which was ceded to Enercon on the 2nd of March 2022.
Ceded on which date?
2nd March 2022.
Proceed.
Your Worship, that's how far back the relationship, as far as the evidence that we could gather. But it should also be noted that Mr. Smaneka Victor Malima also is the beneficial owner of Quality Meat. He's the owner of Eco Trading.
Just hold on. Quality Meat.
He's the owner, he's the 100%, he holds 100% interest of Eco Trading. And he's the beneficial owner of Oshali Fuel Center. Oshali Fuel, something, Your Worship, Oshali Fuel CC, or something like that.
How much stake in Quality Meat Supplies? Does he?
He's the 100% beneficial owner. The entity is, its interest is held 100% by Simeon Anjene Angolo. But in terms of the beneficial ownership, it's listed 100% for Victor Smaneka Malima. So, Your Worship.
Your Worship, may I just suggest that my colleague Nisinda gets a seat somewhere next here.
Mr. Namanja, the court recognizes your gesture. We can proceed.
Thank you. You can proceed, Mr. Inamba.
Your Worship, it was interesting to note that all the listed entities which I've just mentioned now, they were all recipients from the funds that was originally paid by NAMCOR Trading in respect of the assets that were acquired from Enercon.
Were recipients of funds?
Funds that were originally paid by NAMCOR Trading for the acquisition of assets from NAMCOR Trading. We list Mr. Mulunga was still the managing director. In short, Your Worship.
The acquisition of assets from NAMCOR Trading.
By NAMCOR Trading, Your Worship, from Enercon.
You can proceed. Is there anything you want to talk about before I lead you on something, another aspect?
For now, Your Worship,
it's not an objection per se.
Yes.
The fear is simply on account of what happened previously. After all, this is evidence in chief, and my learned friend is well within his right to lead his witness if there is anything specific maybe that the witness wants to add, Your Worship. But remember, It was exactly that sort of question that triggered this witness to introduce irrelevant matter into the record, Your Worship.
I think my colleague is jumping the gun because I did not want to interrupt the witness. That's why I said he can proceed if there is another aspect that he wants to deal with before I step on to another aspect.
Yes, you
Yes,
can proceed.
yes.
Mr. Casper just
Yes.
cautioned, but
Yes.
said you can proceed. Yes.
I think he's jumping the gun. There is no irrelevant
Just
evidence.
proceed.
Yes, thank you, Your Worship. Now, you have indicated earlier on, just before we adjourned, of different amounts that went into different accounts entities. Do you recall that?
That's correct, Your Worship.
Okay. I just want us to deal with them in the following sequence. Just want us to start with the amount of 18,212,000. You recall that?
That's correct.
Okay, just for the sake of completeness of the record, before I deal with the documents that are already before court, how much money went into the account of Eco Trading? Let's start there.
Eco Trading received 9.5 million.
Yes, on what date? If you recall.
Your Worship, I believe that was immediately on the 19th when the said amount was paid to an account ending with a 848 of Enercon,
19 July which year?
2022.
Okay. I just want to deal briefly with Exhibit B3.
This is D. I need B.
On record that I had a discussion with my colleague, Mr. Advocate Rirungwe, in the interest of time, that we will not have problem because most of the payments are common cause, and a number of witnesses have testified and confirming those figures, and the witness in the dock has actually confirmed. We will not have a problem if he directly lead the witness and take the witness to, instead of the witness again reading the same stuff on the record. Those figures are not in dispute. That's why I discussed it with my colleague.
Yes, Your Worship, indeed that discussion was there, but I think just for the sake of completeness and just for the sake of progress, also that there are no disputes in future to say the investigating officer was here, you did not go through those documents with him. I just heard from Mr. Namanje, but I don't know about counsel for the other applicants. That's why I intend doing that, Your Worship.
We have no quarrel with the approach or the agreement between Mr. Namanje and the counsel for the state.
Mrs. Gilbert?
No issue, Your Worship.
Mr. Isaacs, though, on a watching brief?
No quibbles, Your Worship.
I just want to take you to page 4 of that document. There is a date of 19 July. Are you there?
I'm there, Your Worship.
What amount do you see there in the credit side of the bank statement?
An amount of 9.5, that is 9,500,000 Namibian dollars,
Okay.
was
and-
credited into Eco Trading,
okay.
which is having an account ending, a Bank Windhoek account ending with a 823.
Okay. From which entity is that money coming from? In the description, what is the description there?
Enercon Namibia fuel payment, or rather PMT, which I take is payment, Your Worship.
Okay, and thereafter,
A debit of 1 million was made on the 28th of July 2022. Reference or description Venus repayment.
what is that date, sir?
20 July 2022, immediately after the 9.5.
Okay. And all right. Okay. We can pack that bank statement. I want to move on to another bank statement. I want us to move to Exhibit B4, which is a bank statement of quality meat supplies. If the court can just bear with me. The bank statements are quite a lot. I want us to look at the transaction of 20 July 2022. It's on the second. It's on the second page, just towards the bottom of the page. Are you there, sir?
I'm there.
What amount came into that account? On the credit side of the bank statement.
An amount of 1,470,000 Namibian dollars was received. Description: Eco Trading loan payment.
Okay. And below that, or on the same date, the 20th of July 2022,
a payment of 500,000 Namibian dollars was made to Panduleni Farming.
and on the 21st, just below Panduleni Farming, what amount is there, sir?
An amount of 960,000 was paid to CP Willemse.
And on 26 July 2022, I just want, on the same page still,
An amount of 350,000 was received from Enercon Petroleum.
and on 27 July 2022,
the same amount of 350,000 was paid to CP Willemse.
Yesterday you had spoken about an amount of 150,000 that was received by Mr. CP Willemse. I know he's not an applicant in these proceedings, but I just want you to inform us what appears on the date 15 July 2022. What amount is there, sir?
Before you mentioned yesterday, that yesterday you spoke and the witness only started today.
Is it today?
I spoke about it yesterday and today.
Yesterday.
He started yesterday.
Okay.
Yes. I was thinking I'm mistaken, but
Okay.
it started yesterday.
Your Worship, on the 15th of July 2022, a credit of 150,000 with a description EP Logistics was received into the account of Quality Meat Supplies. And thereafter, on the same day, Your Worship, the 15th of July, a debit of the same amount was made in favor of CP Willemse, Game and Goats.
What amount?
150,000.
This one. Let's proceed to another bank account. It relates to Onyeka Clearing and Forwarding. Is it
What is exhibit?
exhibit B5? My apologies. Let's just, do you recall on which date the transaction on that account, sir?
The 19th of July.
Yes. I'll just take you to the page. Yes, it's page 7 of the document.
I'm there.
Yes, just tell us how much money in the credit side came into that account and the reference of the amount.
On the 19th of July, an amount of 3,613,000 was received with a description Enercon Namibia.
Okay, there are two amounts on the 19th of July which are described as management fees there. Do you see that?
I see them.
Okay, there is a 1.5 million there. Do you see that?
I see it.
Okay. I just want you to take note of that. We'll proceed to that one, but to those two amounts, I'll pick that statement for now, bank statement. I want us to proceed to the account of the first applicant, Peter Elindi, which is exhibit B9. Your Worship, if the court can just Okay, so I just want us to go to page. Just want to be exact. Yes, page 39. Yes, page 39. The date of 19 July. This is in the bank account of Mr. Peter Elindi, the first applicant. On the credit side, it's on page 39. What amount do you see there?
An amount of 1.5 million was credited, or rather received, as description management fee on the 19th of July.
All right. I'll pet that bank statement. I want us to move to Exhibit B10, which is the bank statement of the second applicant, Mr. Malakia Elindi. And of interest, I'll take you to page 7 of that document. The date will be 19 July. Are you there, sir?
I'm there.
Yes, can you just tell us on the description side what is the reference there?
Management fee,
Yes, and then on the credit side?
1.5 million.
And just for the sake of completeness, where did this money come from what we have referred to now in the bank statements? From which account did it come from into Malakia Elindi's account?
It was part of the 3.6 million that was paid into Onyeka Clearing and Forwarding.
All right.
After it was received in Onyeka, 1.5 was one of the transactions made.
I just want us to move to exhibit. No, before I do that, I want to proceed to Panduleni Farming CC, which is exhibit B6. And of interest, I want us to start on page 1 of that document. Are you there, sir?
I'm there.
I want us to proceed to the date 20 July 2022.
I'm there.
What in the description side, let's start there. What is there?
The description is quality meat supplies,
And on the credit side?
500,000 Namibian dollars.
And then there is also an amount on 5 October 2022, just on the bottom of that page, saying what in the description side first. On the bottom of the first page.
Yes, I'm there.
Yes, yes, sir.
The description is transfer deposit, quality meat supplies,
And the amount?
100,000.
And let's proceed to the second page. The date 26 October 2022. In the description side.
The transfer deposit, quality meat supplies,
The amount?
100,000.
All right. Let's proceed on still on the same page, 17 December 2022. On the description side
Quality meat supplies,
and the credit side, sir.
500,000.
All right. I want to park that bank statement there. Your Worship, I want to proceed to Exhibit F, which is the affidavit, which also contains the bank statement of Venus Technology that relates to a client of Mr. Casper. Now, Mr. Inamba, I just want us to proceed on that bank statement. It's actually the last page, Your Worship, of that document. It's written page 3 of 8. Are you there, sir?
I'm there.
Yes, there is a date of, let's start the one on top. 4 August 2022. Do you see that?
That's correct, I see it.
In the description, what does it say?
Erongo P,
On the credit side, how much is there, sir?
10,000 Namibian dollars.
And then the date underneath there, what is the date?
4 August 2022.
And the description side,
Olivia Dunaiski,
and the debit side?
10,000 Namibian dollars.
Okay. Now, I just want us to deal briefly with the affidavit of Ms. Dunaiski, amongst other things. I just want you to comment. Your Worship, on page 7 of the affidavit, paragraph 21. Mr. Inamba, just as a preamble, just want to inform you that I think from the onset in these bail applications, it has been said that the state's case is very weak. In fact, the adjectives weak has been used. So I want us to proceed on that premise. So on that paragraph, I'll read to you and I just want to hear your comment. It says, the state believes that they have a strong case against me. I do wish to highlight, as has already been demonstrated by other core applicants, that the state's case is a weak one. I fully embrace same and associate myself therewith. It has also been established that the so-called serious charges can best be described as being chaotic. What is your comment with that aspect, saying the case against Ms. Dunaiski is a very weak one and chaotic one?
Your Worship, I feel I'm prematurely answering this question, and why I'm saying so is I think at the point when I get to the charges that Ms. Dunaiski is facing, I will be able to provide an in-depth response. But as it may, Your Worship,
I'll just give you the charges if we can proceed in that manner. I'm referring to Exhibit D2, Your Worship. D2. I just want to get to the correct charges. Yes, the charges against The applicant, Ms. Dunaiski, starts on page 12. And I'll proceed to page 13, count 32, which relates to fraud. And I'll read it to you so that at least you have an idea for what we are saying. Yeah, it says in that during the period 8 July 2022 to 4 May 2023, and at Onyeka Windhoek in the district of Windhoek, they said accused did wrongfully, unlawfully, and falsely with intent to defraud, give out and pretend to Enercon Namibia Pty Limited, that is an employee of NAMCOR, to wit commercial manager. She had the board approval to purchase service stations from Enercon Namibia Pty Limited, and therefore caused NAMCOR to suffer an actual loss of 53,212,000, whereas in truth and in fact the accused, when she so pretended, did not have the board approval. Therefore the accused did commit the crime of fraud. There is an alternative to that charge of theft by false pretenses, which also relate to, let me just read it to you. I'll read it to you just for the completeness of the record. And that between 8 July 2022 and 4 May 2023, and at Onyeka Windhoek in the district of Windhoek, they said accused it unlawfully and with intent to defraud and to steal, misrepresent to NAMCOR, that as a commercial manager, she had the board approval and authority to approve the purchase of 9 service stations from Enercon Namibia Limited, and did by means of the said misrepresentation obtained from Venus Technologies cash in the amount of 10,000, whereas the said accused, when she so pretended as aforesaid, well knew that she was not entitled to receive money for her own use and benefit. Thus the accused did commit the crime of theft by false pretenses. Do you get that?
I get it.
Okay. Now, in relation to what I just read to you in paragraph 21 of the affidavit, saying firstly that the state's case is weak against her and that the charges against her are chaotic. What is your comment, sir?
Your Worship, I don't think the state would ever, secured the attendance of Miss Olivia in this courtroom if there was no evidence that she had committed an offense. And remember, Your Worship, when we are talking about corruption, for example, I know Your Worship hasn't read the charge of corruption as an example. We are not looking at the value that is involved. We are looking at the element of the gratification that was provided. Fraud in itself, Your Worship, it's a serious offense, which I believe
you can proceed.
Yes, which I believe, Your Worship, she committed this offense whilst she was executing her duty as well, which resulted in exposing NAMCOR Trading to an actual loss of the same amount.
There was also an issue that was raised during the trial with regard to the manner in which the accused persons were arrested, in that the ACC, the Anti-Corruption Commission, did not afford the applicants an opportunity to explain their charges. Therefore, there was no need to arrest them. Let me leave it there. Can you comment? They were not given an opportunity to explain, so therefore there would not be a need to arrest them if they had explained.
Your Worship, Namibia is a democratic country. And when individuals are arrested, they are given an opportunity. Firstly, they are informed of their legal rights.
I think the mistake is coming not necessarily, maybe from my colleague, because slightly he misrepresented what we said. The point, the witness is answering about an opportunity at the arrest. That's not what, at arrest we complained about them at arrest not being promptly and fully informed of the ground of arrest. But we have another point, which was prior to them resorting to arrest, our clients were not given an opportunity. The witness must also listen. He was asked a question in relation to not giving an opportunity before arrest. Now he's answering in a democratic country at arrest. I think really.
Any comment?
I think the witness was still explaining, because I had qualified the question to say, prior to you arresting them, you didn't afford them an opportunity to explain. Therefore, there would not be a need for you to arrest if they had explained. So perhaps you can answer on that premise, because I hear the concern. Yes.
Thank you, Your Worship. Your Worship, the Commission believed there was sufficient evidence to secure the attendance of the accused persons to court. And therefore, a decision was made in order for the accused persons to be brought to court. And in this regard, it was through the method of arresting the accused persons.
In terms of your duty at Anti-Corruption Commission, you just maybe for those that don't know, at least for me as well, is there a duty to first seek an explanation from an accused before you effect an arrest? Or what happens around those circumstances?
Your Worship, one cannot say that it's mandatory for a person to give an opportunity to somebody to explain. It really depends on the merits of the case that is at hand. But Your Worship, we also know that should you be asking a person that you suspect of having committed an offense, such a statement, even if you were to obtain it, you can't use it against them.
And there was also an issue made in this court with regard to the time that the applicants were arrested, in that their rights were not explained, or the charges were not explained to them, and that you just mentioned certain sections of the Anti-Corruption Act to them, without explaining the charges to them, but you just quoted some sections in the Act. What is your comment?
Your Worship, before we commenced with the arrests, we had a meeting with all the parties that were involved, in which background to all the charges was provided, specifically to the people that were not actively involved in the investigations. Firstly, Your Worship, when the people were arrested, the officers introduced themselves and provided the reasons as to why the officers were there: to execute the warrant of arrests on a case that was being investigated by the Anti-Corruption Commission, and background, Your Worship, was given as to the nature of investigations. For example, the supply of fuel to Enercon to this amount, or the supply of fuel to Erongo to this amount, and as well as the acquisition of assets to this amount by NAMCOR from Enercon. And of course, Your Worship, the sections were explained as far as the preliminary charges that were used to obtain the warrants of arrest.
I'll get back to Ms. Dunaiski's affidavit. I just want us to clear up some few things. There was also an issue made by the second applicant, Mr. Malakia Elindi, in that upon arrest he was not afforded an opportunity to find someone to live with the kids. In fact, his arrest is said to have been not procedural, if I can put it that you did not comply with the procedures. You arrested him arbitrarily without affording him an opportunity to find who he lives with the children and to arrange his affairs. That's what he said in short.
No, that's not what was said. Remember, Your Worship, your notes will tell. He even explained when he was being cross-examined. Remember, Your Worship, that my client was even asked that question, and he explained that I said without their parents. That issue of looking for somebody, remember he then disclosed that when he was asked by Ms. Hinda, who did you live in the house? He said, it's my second wife. But why did you say no? I told them my complaint was that kids were left in the house without their parents. We needed to find, for school purposes, a neighbor to stay with the child. That is not exactly what my colleague said.
Yes, Councillor.
But of course, but my colleague is fair, Advocate Lurungwe. I don't think he was present at the time Ms. Hinda was clearing it up. It may be because of that. I'm not blaming him.
That's in order.
Okay, just broadly, I just want you to explain to us the procedure that was followed when you arrested the second applicant, Mr. Elindi, Mr. Malakia Elindi. What transpired there?
Your Worship, I was present at the residence of Mr. Malakia Elindi myself. In fact, I was one of the first people that had arrived there, Your Worship. We arrived there first because my team was headed to the house of Mr. Peter Elindi. Unfortunately, we could not get a response there. We list the other team that should have been to the house of Mr. Malakia. Was on their way to Pioneers Park, Your Worship, if I'm not mistaken, where the address that we had at the time was for a house or for a place in Pioneers Park. They could also not find him. In fact, they spoke to, I believe, a tenant there. But by the time they spoke to the tenant, myself and one other officer arrived at the Windhoek residence of Mr. Malakia. And we knocked. When we knocked, I personally knocked. The wife of Miss Malakia, Miss Lydia Elindi, is the one who came by the gate. Before she opened the gate, we introduced ourselves. In fact, after we introduced ourselves, she welcomed us, she opened the gate. We inquired from her, Your Worship, if her husband was in the house, and she confirmed he was. And thereafter we asked, we are still at the gate. I asked her, and what was her name? And she indicated she was Lydia Elindi. And I informed her we were also looking for her, we wanted to talk to her. She invited us in the house, Your Worship.
Proceed.
To which, yes, we were we were 4, Your Worship, because we had 2 cars, the 2 officers from the police and 2 officers from ACC. When we walked in the house, I stepped outside where I called the team that was in Pioneers Park and sent them the location, informing them that we are at the residence of Mr. Malakia Elindi. Until the time they arrived. So in the meantime, we sat with Mr. Elindi and his wife. I was outside. I didn't go back inside because at that point we did not have the warrants of arrest. When the team the team that was having the warrants of arrest arrived, Your Worship, we got in the house. They came with 2 cars as well. Where we sat in the living room with Mr. Malakia and his wife. The officers from NAMCOR executed the warrants of arrest in which they were informed of their rights and the charges that was against them, Your Worship, and that they were placed under arrest. Your Worship, at that point in time, they indicated they would even call the brother, referring to Peter, so that we can wait for him at the house. Your Worship. And we gave them the opportunity to call. We inquired from them if there was somebody at the house, how many kids they had in the house. At that point in time, they said they would call somebody. And we thought they had called, Your Worship. Your Worship, I know the wife was not very conversant in English. Such was translated. And I requested the team, 3 women, Your Worship, to accompany her upstairs to their room, which I believe was upstairs, Your Worship, as I stayed in the living room. We list myself personally, Your Worship, seated next to Mr. Malakia, provided him with a background as to why the case, what case was being investigated. The case pertained to the supply of fuel. The fuel that was received by Enercon, provided the values, and the asset purchase agreement. The assets that were purchased from Enercon. Taking into considerations, Your Worship, that the offenses were already explained, and I gave him the background that this is the nature of investigations. Your Worship, I remember as the team came down, we had to switch because the Lydia Elindi had to go and change. She was wearing a gown. So when she arrived back, we had to switch so that the other officers can accompany Mr. Elindi. The same was done. We sat with Miss Lydia and explained. In fact, the explanation for Miss Elindi was one of the easiest one because it pertained to an amount of 3.8 that was paid into Onyeka. So that was done, Your Worship, and to make sure that they understood, I remember even when they were charged, I personally went there to make sure that if there's anyone who didn't understand, because some of the people were in shock, I personally went there, Your Worship, where I sat with each one of them and explained to them. Specifically the ladies, Your Worship, I remember when we sat at Windhoek, one of the colleagues even asked me, Inambao, you are too passionate. And I indicated that I need to make sure they understand. I went one by one, making sure that such was explained, Your Worship. Similarly for the gents, Your Worship, in Sears. In fact, Mr. Kadondana should have come there, but on the request of his client, he said there was no need, as he was going to remain silent anyway. But still, we tried to explain, the charges, where they come from, and so forth and so on. In fact, Your Worship, I remember going from section to section, explaining this is the offense relating to A, B, C, and D.
Okay. I'll get back to the arrest, but with regard to Ms. Hamukwaya, but I just want us to complete the affidavit. Okay. On paragraph 22.1, it says, as already stated here in above.
That is, are you saying paragraph 21?
No, 22.1, Ms. Dunaiski's.
Ms. Dunaiski, because you
maybe,
mentioned Ms. Hamukwaya.
No, it's a slip of the tongue. I apologize.
Only one is said to be the media worship.
In fact, what I wanted to say is we'll get to the arrest of Ms. Hamukwaya later, but I think it got dragged. Yes. So I'm saying on paragraph 22.1 on page 7 of Ms. Dunaiski's affidavit, it stated, as already stated here in above, I was an employee of NAMCOR Trading, underline that, and not NAMCOR as the state alleges. Now, I just want you to comment, if you can, because there was an issue with regard to NAMCOR Trading and Distribution, if I can complete it, and then NAMCOR, the parent company. Can you just explain or comment around that?
Your Worship, I believe the appointment of Ms. Dunaiski is part of the evidence. Your Worship, whether she is an employee of NAMCOR Trading or NAMCOR Holdings, at the end of the day, Your Worship, is a question about the conduct. And this is a question relating to the fuel that she authorized above the credit limit, which was done from NAMCOR Trading.
With respect, what is this witness doing? The witness was asked a specific question to assist counsel for the state, which was a good question, to simply testify about the employment in relation to two companies, NAMCOR Trading or the holding company. His duty is to answer question, not to argue the case for the state. And he has been doing that. It's not for him to start, it doesn't matter what is in question is the conduct. The witness is arguing. Are we starting to argue this case now? With respect, the witness must just stick to the question.
Also, it is quite important that context is adhered to. You will note, Your Worship, that paragraph 22.1 says, as already stated here in above. So, and then it is clear, Your Worship, if the court has reference to paragraph 5, that the employment details of the sixth applicant appears there, and you will note, Your Worship, that there is a reference made to an annexure, which is the contract of employment. So, I mean, there is no need for this witness to reinvent the wheel and try to interpret what that means, Your Worship, and to render an opinion to this court that has not been solicited from him. The facts are there.
Counsel, any response?
I think I'll just simplify it for the witness so that we move. Mr. Inamba, do you know in your investigation whether there was a difference between NAMCOR Trading and Distribution and NAMCOR, the parent company?
Yes, Your Worship.
Yes, you can proceed.
NAMCOR Trading is a subsidiary of NAMCOR Holdings.
All right. Paragraph 22.2, I'll read it to you. Contrary to what the state is alleging, I had no authority to increase any credit limit, and I certainly increased no credit limit as alleged.
Your Worship, documentary evidence was obtained to prove, and in this regard, Your Worship, there is evidence indicating that she approved the supply of fuel to Enercon Petroleum CC, and as well as Enercon.
Okay, paragraph 22.3, I deny further that I corruptly used any public office for gratification. I, in any event, occupied no public office. I just want us to deal with the aspect of corruptly use any public office for gratification and the issue of public office. I think let's deal with that first. She denies that she corruptly used any public office for gratification. What is your comment?
Your Worship, maybe it's because I don't have the full statement, but gratification is a gratification, whether a person is in the private or public.
And in fact, what the applicant here, Ms. Dunaiski, says, she denies that she did not occupy any public office. What is your comment?
Your Worship, I can't say NAMCOR Trading is a public office, but it is a subsidiary of a public enterprise. But Your Worship, in terms of the Anti-Corruption Act, it does not only regulate corruption in the public service. This is a piece of legislation which regulates corruption in the entire country, whether private or public service or public enterprise.
Okay. Paragraph 22.4, still on page 7, she says, I'm unaware of any sale of the 9 service stations. As far as I'm aware, there was an asset purchase agreement concluded between NAMCOR Trading concerning the rights, interest, and title to assets owned by Enercon. If you have any comment, you can comment.
Your Worship, the submission that was made on the 8th of July 2022 was initiated by Ms. Dunaiski, and Your Worship, the information contained therein, I'm sure it's contrary to that statement. Your Worship.
And on page 8, paragraph 22.5, I'll read it to you. I have never conspired with any of my co-accused and or anybody else for that matter to commit any offense, nor have I received or accepted any gratification. In short, she's denying conspiracy with anyone, and she says she has never accepted any gratification.
Your Worship, conspiracy started when the planning for the acquisition, or rather for the purchase of the service stations, Your Worship, or fuel storage facility. That is where the conspiracy started. And Your Worship, the offer, the commercial offer that was made by Mr. Mulunga to Enercon was made based on the submissions which Ms. Dunaiski was the author of.
Further, still on paragraph 22.5, It reads, I have seen the several bank statements the state has provided herein relating to various payments made. I do unequivocally state that none of those transactions relate to me. But of interest, I have not received any of the payments reflected therein. Would you have a comment?
There is a 10,000 Namibian dollars that was paid from Venus Technology into her account, Your Worship.
I see my learned friend conveniently skips 22.4. Why are we skipping if we are dealing with the affidavit in its full context and glory?
I don't think I can be cornered to put. I'm putting what is relevant to me. I think there's been an issue of relevance. He will have his opportunity to ask this witness. So I'm putting what is relevant for me for the witness to comment. That's why I did not, because I think that was not of interest to me. And I think that's why I emphasize of interest.
Your Worship, the only reason I'm making this issue, you'll remember now, my learned friend refers to, or the witness refers to an internal memo that is said to have been prepared by Ms. Dunaiski, Your Worship. But 22.4 gives context to those circumstances, Your Worship. And because this is where the state's case fumbles, the state conveniently jumps that part of the evidence, Your Worship.
Yes, I think, do you have any response or?
I think I've responded.
You have
I say
responded,
I'm
yes.
putting what is relevant for
Yes,
my case.
I think
need
this,
be, he can ask
the
him.
state have put its position. Yes, that's why you are here, counsel, to deal with the other issues. Yes, so we can proceed.
I don't know if there was an answer from the witness.
Sir, what is your answer on 22.5, the last part?
She did receive 10,000 Namibian dollars in her account. And Your Worship, perhaps to explain gratification, gratification, Your Worship, does not carry an ordinary meaning. It also carries a technical meaning, in a sense that a gratification, even if the individual themselves don't receive it, it can be created for somebody else, directly or indirectly. And Your Worship, this is what we could find in the account for now.
I'll move on to paragraph 22.6. It reads, I have made no misrepresentation to anybody as alleged by the state. I'm advised that the state has in any event failed to specify the person to whom I may have made any misrepresentation that was intended for NAMCOR as alleged. Do you have a comment that, in short, she's saying she made no misrepresentation to anyone as the state alleges?
Your Worship, there was a potential, not a potential, an actual loss was suffered by NAMCOR Trading. And in this regard, the misrepresentation was done to NAMCOR Trading because they paid out the money.
Okay, in paragraph 22.7, I do confirm that an entity known as Venus Technology CC on 4 August 2022 I'll read it as it is. I do confirm that an entity known as Venus Technology CC on 4 August 2022 in the amount of 10,000. The payment was not for any moment in respect of any NAMCOR trading, NAMCOR related matter. The payment was made in respect of consultation I did in relation to a feasibility study for an intended medical center. Do you have a comment? He said the payment, the 10,000 was for a consultation fee, if I can say put it in that for a feasibility study?
Your Worship, Erongo Petroleum at the time was conducting or had a relationship with her employer, subsequent to which she was responsible for approving or authorizing the supply of fuel. In fact, Your Worship, the specific account received part of the proceeds of the money that was paid by her employer for acquiring, the alleged assets, Your Worship.
Okay. By the 4th of August 2022, was the applicant, Ms. Dunaiski, still employed by NAMCOR?
That's correct, Your Worship.
Do you know from your investigation whether she could do any consultation while employed for NAMCOR?
No, Your Worship.
All right. Now, just to wrap up, or maybe just one aspect, I'm moreover advised that I do not have to, at this stage of the proceeding, deal with any of the merits of the charges against me, and all I'm required to do is to put up a sufficient basis upon which this court can consider how weak the state's charges are. In fact, weak is spelled as weak for the weak. This is very weak. Yes. So, do you have a comment?
We can take jabs. Look at the state's charges riddled with spelling errors and grammatical issues.
Yes, we can proceed.
Yes. Do you have a comment, sir?
Your Worship, I believe during the course of partial yesterday and today, I've provided evidence to this court, Your Worship, evidence of the undertakings as to why the charges has been brought up against the accused persons. And Your Worship, even before the accused persons attendance was secured to court, there was enough evidence to prove that there was a strong case, or rather evidence in this regard.
Okay, I just want you to comment. There were issues from the onset with regard to the charges that this is a commercial transaction that should have been handled in a disciplinary hearing or in arbitration. In fact, had the accused persons known, or let me leave it that before I put on the next question, that this is a commercial transaction which should have been dealt in a commercial court. It has nothing to do with fraud. Do you have a comment?
Your Worship, my comment is going to be in two folds. For example, if you look at the agreement of Erongo, which was signed sometimes in 2020, Your Worship, I cannot say that there was ill intentions to that. But the preceding actions which happened where money started to be paid to staff members, and these are the staff members that were actually making authorization for the supply of fuel above the credit limit. Your Worship, this is where the problem came, and it became an offense in this, or rather it became criminal. So even if the origin was commercial, the later or the preceding actions ensured that it escalated into a crime. That is in respect of Erongo. Your Worship, in respect of the purchase of the asset, it's very clear that the moment this money was paid, it was distributed into various entities, which among others including entities held by staff members or their relatives, Your Worship. So you can see the conduct from there. So the state is very confident that this is not a commercial transaction. Similarly, with the fuel supply agreement of Enercon, you can see in terms of how it was planned from the beginning, from October. the conspiracy, you start looking at it from there in a sense that, you know, Ms. Hamukwaya was given access to this account. It's not known as to why she was given authority. And then from there, there was a cession of a debt, which we are not saying there's something wrong with it. But then there was an agreement, or part of the agreement was that money would be paid in a specific account. The money was not going there, which resulted in losses. And both representatives of Enercon and representative of NAMCOR, they were aware of this. So, Your Worship, my response is not a commercial transaction.
Yes, just to conclude, I just want to hear your comment with regard to the following that has been said also. It is being suggested that the accused, the applicants, actually knew that the ACC was investigating them. If they wanted to abscond, because part of our grounds of objection is the risk of absconding. If they wanted to abscond, they would have absconded way back because they knew of the ongoing investigations against them. What is your comment?
Although they may have known, Your Worship, they did not know when they will be arrested. Your Worship, this is part of the reasons why the vehicle that Mr. Mulunga was using is missing. It's because he had known. And Your Worship, if he had known and still kept the vehicle, that would have been very good. But now that vehicle is not there, Your Worship.
Your Worship, I think it's on record that that vehicle was never owned by Mr. Mulunga. It's owned by a certain Yeleni Kamati, if I'm right. Please report, Your Worship.
Your Worship, may I proceed? There are a few things that I still want to...
You can proceed.
Okay. I think I won't be long. There is just an issue. You had indicated that... You had indicated that the agreement of the payment of the fuel was to be paid into the 520 account. You recall that?
That's correct.
Okay. And you've also indicated an issue with regard to the purchase order, if I'm not mistaken. You recall that?
That's correct.
Your Worship, I want to introduce a document to this witness. I won't be very long with him. It's just...
No, take your time.
Yes, so... Yes. I just want to give you a document, or before I do that. Yes. So, you are aware that there was a 520 account of Enercon and an 848 account?
That's correct.
Okay. And would you recall in which account Enercon would receive money paid by the Ministry of Defense?
In terms of the fuel supply
Yes.
agreement, the money, or rather the funds, should have been deposited or credited into the account ending with 520.
Okay. From your investigations, did you establish with regard to who has to supply a bank account into which money has to be paid in relation to this case?
Your Worship, Enercon was supplying defense, or the Ministry of Defense, with fuel. So in this regards, Enercon would have to issue an invoice to Ministry of Defense. And The invoice would, among others, include the account details in which the funds for the specific services that were rendered should be credited to.
Your Worship, with leave of the court, I just want to quickly deal with this document. It's the
as has been the fashion by the state,
Yes.
again, just as we were about to commence proceedings, those documents were provided to us. Your Worship, you will recall we have had numerous complaints about the manner in which documents are provided to the defense on a piecemeal basis. Now, Your Worship, you have made a very firm ruling in these proceedings on previous occasion, where you have said this court concerns itself with conducting a bail inquiry and not a pre-run at a trial, Your Worship. But mostly, Your Worship, this sort of conduct is prejudicial and unfair to the accused persons. They've not been presented with these documents when they led their evidence in chief, Your Worship, so that they would have had an opportunity to forthright deal with these issues as and when these documents were availed to them, Your Worship, to deal with. Your Worship, this is prejudicial. This amounts to a violation of the accused person's Article 12 rights, Your Worship. This is an ambush.
Any response?
Your Worship would recall, in fact, when the first applicant and the second applicant actually testified, reference was made to purchase orders that have to be issued for the supply of fuel. Reference was made to that. In fact, it is not in dispute that Enercon in fact had two accounts, 848 and 520. So, I'm seeking to introduce this document on that premise that there is firstly the mention of the purchase order that has to be issued for the supply of fuel, and secondly on the premise that it is said it was up to Enercon to decide in which account money has to be paid. So that is the basis of my question, or me introducing this document. And lastly,
But if
this document was
maybe
introduced.
Before you proceed,
Yes, ma'am.
If I understand Mr. Casper is saying it was never availed to the defense to deal with it. That is his
It's
the issue.
true from the onset,
Yes,
because
so can you deal with that aspect?
we disclose as we go by, Your Worship, because it's not a trial. We are not here. The standard of proof is not beyond reasonable doubt. So that's why we disclosed the document to them. I agree it was disclosed to them today, but they should take notice that the standard of proof at these proceedings here is not beyond reasonable doubt. In fact, they had also been disclosing documents with regard to the houses and other things as we proceed. They are the applicants, so I do not see any prejudice. That is the short word of what I'm saying.
Your Worship, I think there is a problem here. And I think maybe it's because of the statement this court made that bail proceedings are easygoing. But because it's easygoing, Your Worship, does not mean accused persons must suffer prejudice. Your Worship, you will recall part of the challenge mounted by Mr. Namanje in respect of how pathetic the state's case is was that, Your Worship, despite the state alleging purchase orders were not containing the account 520, they failed to at least provide these so-called purchase orders and invoices so that the bail applicants would have dealt with it. But Your Worship, the bottom line remains. The state cannot, because they have in passing mentioned, or because a bail applicant has in passing mentioned the existence of purchase orders and invoices, through the back door come and introduce them, Your Worship. that remains ambush. And I'm glad my learned friend at least tells this court, because maybe the court made the comment that bail proceedings are easygoing, that they can just drop these things as we go along, Your Worship.
Your Worship, that because it pertains, I didn't realize that it's pertaining to my client. It appears that the whole purpose of handing up this belated document is for purposes of proving something, I don't know what it is, against my client. But Your Worship, you have been on the bench for a number of years. Every day you invest your energies and everything, your soul, in a pursuit of justice in this court. And we come to this court expecting that is exactly what we find here. When I was doing one case many years ago, somebody cried in the corridors of court and say, we come here for justice, but when we come here, it's just us. No justice, just us, being harassed and being subjected to unfair proceedings. Now, Mr. Elindi is there, and Mr. Malakia Elindi is there. They have closed their case. At the beginning, my colleague, Mr. Casper, is correct. I went against the state saying their case is in chaos, it's pathetic, it's true. And I did. In fact, I did in a proper way, legal way, instigate them, trying to trigger them, trying to seduce them to do something, which is to ensure that they provide us with documents so that my client has an opportunity, so that by the time the respondent goes in the witness box, my client's version is already known. Now these documents being, what if my clients were saying, oh, you are talking about these documents. We were directors, these documents are prepared by my administrative staff members, and they may have made a mistake or so. So the state, it appears deliberately, now wait until my client, despite me demanding, give us those invoices. Remember, Your Worship, I placed it on record. I was demanding, then give us those invoices. After closing of our case, the documents are produced. I place on record that you will see when I start cross-examining the investigating officer that from day one, the state was playing and handling this matter with dirty hands. And this is a continuation that they can just subject my clients to any process, whether it is fair or not. So we leave it to the court to decide what should happen with this, because my clients are done. And I cannot, even if I take instructions in nugatory, it's futile because they can't comment. So this strange scenario really is incompatible with all the tenets of justice in our country. High-profile people must also get justice. In a TIEC judgment, the Supreme Court says it doesn't matter what position you hold, poor or rich, you can never be treated in a harsh manner just because people think you are rich or you have a high-profile position. Those are my submissions.
I may address the court. I'm not sure if the court recalls, but I myself introduced this docket when the second applicant testified. That was Malakia Elindi. I handed the document to the second applicant. The second applicant commented on this document, and then Master Namanje then objected, and then he said this document can be dealt with at the time that the investigating officer testifies. So the only thing that we'll probably apologize to is that we only handed this specific document to the legal representatives this morning, but insofar as it concerns the second applicant, the document was handed to Master Malakia Elindi, and he commented on the document. Your Worship can look at the transcribed proceedings. No, it is.
No. I placed it on record. I only saw these documents today.
Just a minute. It's in order. It's
Yes.
in order. Yes, you have made your point.
Thank you, Worship.
Yes. Yes, now, before I proceed, I have on numerous occasions mentioned correctly that bail proceedings are easygoing. In fact, it's not the words of my own making, but it comes from case law. You can read the case of Sekunja versus the state, CC 19 of 2017, High Court of Namibia, Main Division, delivered on 22 July 2020. I am specifically looking for that word, but so that I can quote it. So it's just in the heat of a moment now. I cannot get it where it's stated, but that is where it's coming. But then the court, yes, the court, for example, proceeds that at paragraph 26, not specifically that word because I know I've circled it, but I cannot see it now in the heat of the fact that no rigid procedure is prescribed for bail application is indicative of the appreciation of the sui generis nature of such proceedings. It is the duty of the judicial officer to justly conduct the bail hearing in a manner that will ensure that both parties are properly heard without overlooking the inquisitorial nature of the bail proceeding. I'm specifically looking for the word easygoing because that is where I took it from, but at the moment I cannot. But with that said, having listened to the party, both councils are agreed that this is a bail application. It is not the trial. The court is only concerned with the bail proceedings. The rest of the issues will be dealt at trial if the matter gets there. Therefore, having heard the submissions of both councils, the court is in agreement with the submissions from the council for the applicants, that issue can be dealt with. That issue, get what?
Paragraph 13.
Paragraph 13. Okay, let me just read it for the benefit of Mr. both councils and specifically Mr. No, I'm going to read it. Let me read it for you so that we can understand. At paragraph 13 of the said judgment, the court quoted the judgment of Demott J. in S versus Nicholas and another, remarked as follows regarding the process of making ex parte statement from the bar in bail proceedings. It is a notorious fact that in the majority of cases, ex parte statements are made both by the defense and the public prosecutor, who intimate what the parties' objections are. There are no formalities, no evidence is laid, no affidavits are placed before court, and the record is so meager that there may be little or nothing to place before the Supreme Court if the matter is taken on appeal. this easygoing procedure has both advantages and disadvantages. Accordingly, it does not mean to me that this court will be justified in declaring that there can be no appeal to the Superior Court unless full information on oath is placed before the magistrate. You would recall that I have made the reference at the time in one of the rulings to this aspect of that because there was no affidavit, it was not commissioned, therefore it was not an affidavit. In the same way, I have indicated that because, for example, I cannot specifically recall at that moment what I said, but it's on those lines. So bail, in fact, case law says it's easygoing. So it's not my own making. Yes, for that reason, the rest of the issues can be dealt with at trial. This is a bail application, so we can proceed.
Your Worship, so the ruling is
The ruling is that the state can deal with those issues at trial. For now, yes,
Thank you, Worship.
they were not disclosed. To give them to counsel, it will be prejudicial. It can be dealt with.
Your Worship, I equally embrace the sentiments that bail proceedings are easygoing.
It's in order. Now I'm looking at the time now, it's about 16:30, because we still have administrative issues to deal with when we go off air. So is the matter rolled to tomorrow by agreement?
We can proceed tomorrow at 9.
Tomorrow, okay.
Yes. Oh, yes.
Tomorrow
Yes.
9 o'clock.
9, I'll be here.
Okay. Say you are still under oath and you are warned for court. Applicants and accused, the matter is rolled to tomorrow to proceed at 9. Yes. The court adjourns.